Hello and welcome to another episode of Permitted with Conditions. I'm Sam the intern, and let's get things started with part two of our interview with Joe Tovar.
As I mentioned in my introduction, you were one of the original members of the Growth Management Hearings Board, which today is a consolidated board. But back when you were appointed, there were several boards divided around the state based on region. And so just was kind of curious that being an initial court of competent jurisdiction that heard and decided some of the appeals on whether growth plans in the early stages of growth management were compliant with the requirements. I obviously don't want to put you on the hot seat about any specific cases or anything like that, but I'm curious just what that experience was like for you, having had the opportunity to work on the Growth Management Act itself, and then having this opportunity as it's being implemented to weigh in on all of these kind of issues as jurisdictions, communities, environmental groups, builders, and everyone else kind of struggled to figure out, within that legislative guidance, what does this mean and how does this actually then, work?
It was a very interesting 12 years. The legislature, when they created the growth boards process in 1991, had a couple of models they could look at, one of which was Oregon. They looked at the Oregon process where appeals of city and county plans and regulations in Oregon went to something called the Land Use Board of Appeals, which is a single statewide appeals body made entirely up of lawyers. So it is a true land use court. I think our legislature borrowed some things from Oregon, but consciously did not want to borrow some things from Oregon, one of which was the idea of a single board. So they adopted a system with three boards, one for Central Puget Sound counties and cities, one for the rest of Western Washington, and a third one for Eastern Washington. So they wanted to have some regional diversity in the structure of the boards. They also didn't want to have all the members of the board be attorneys. Now, I'm not an attorney. The boards had to have, in our case, each board had to have at least one lawyer, one former local elected official, and then some people think the third person had to be a planner. Well, the statute does not say that. Just so happens I am a planner, but all three members have to have experience in land use, local government. So I was appointed to the board. The attorney member frequently, as you might expect from his experience and background, had a perspective that was largely looking at what does the law say? What does the legislature intend? Looking at it from a very lawyerly point of view, the former local officials that I worked with on the growth board frequently were focused on what is the political reality of what the legislature must be meaning and intending here. And to some extent factoring in what can you realistically expect local elected officials to make of all this and to do if we're going to respond with a decision that requires them to take some action. I think the former local elected official probably had a deep insight into what might be a way they could react that would be compliant, in our view, with the requirements of the law. As the planner, I listened to the lawyer, I listened to the former local elected official. We deliberated on all these cases and all these decisions, weighing the arguments that we had heard, trying to intuit what we think the intent of the legislature was in answering the question, did the city comply, did they not comply? Did the county comply, did they not comply? Why did they not comply? Well, we had the arguments from the attorneys for the petitioner and for the responding city or county in front of us. We had lots of good lawyerly legal argument saying, here's what it must mean, here's why we're compliant, or here's why they're not in compliance. We had to weigh all that, talk about that. So we had the legal perspective, we had the political perspective, we had the planning perspective, and each of these are not exclusive. I mean, I understand the law to the extent I think I needed to understand the law. I understand the politics. I worked for local elected officials for several decades. And so I think it was a really good balance of perspectives. We agreed on almost all our decisions. There were some dissents. Occasionally somebody would disagree and say, well, I can't go along with the other two people, so here's my dissent and here's why. So that happened a couple of times, but overall, I think the process was very collaborative. It was very deliberative. It was interesting to me to listen to people argue about what the law meant or did not mean. And again, one thing I have as a takeaway from my experience there is the law is not mysterious. I think, people shouldn't think of the statutory language itself or even the briefs, or most of the briefs filed by lawyers, as some arcane, mysterious, secret language that only lawyers can understand. I mean, you strip out all the Latin, the supra, the infra, get that all out of there. It's basically narrative that can be understood by most people. So I think that it was an interesting process. It's a administrative law process. These are lawyers and non-lawyers saying, here's what we think the legislative intent is, where these blanks or these gaps exist in what the statute says. And that was really interesting for the first 10 or 12 years that I was there, because these were, I think, as you said, David, cases of first impression. Somebody would say, what is urban growth? Okay, let's argue about that. And here's what we think it means. We then would make a decision, say, here's our rationale. A wins, B loses. People then could accept that, or they could appeal that and go off to Superior Court and then ultimately on to the appellate courts to get a more definitive answer. But it was really interesting to me to listen to people give different perspectives on what they thought the law meant and why. And I'll talk a little bit about some of the cases that we decided and why I think the answers that we gave to some of those cases made good law, good policy, and I think realistic politics.
Yeah, thank you for that. I just want to say, just in my experience, I was kind of in a couple of cases part of the group working with petitioners on some hearings board cases back in the day, and then also on the side of having some things that we had worked on behalf of clients that got appealed to the growth hearings board. And kind of really the two things that have always stuck out to me the most, I think were both very well articulated and defined by the board early on, was kind of the importance and the strength of public participation in the process. And I know the board spent a lot of time in early decisions, questioning whether there had been, a robust enough public process associated with things. But then also the show your work kind of standard. If you go back, at least my read of a lot of the old cases was, okay, that's great what you've decided or what you believe the plan should be, but where's your support for that? Where's your record, your evidence? Where's the data? And I think that was, to me, that was really profound. The board kind of, focusing in on some of those things, which is, you have some freedom and some flexibility to plan within the statute, but at the end of the day, you still also have to be able to have this basis, this record by which that is defensible as a rational decision. And so those two things have always kind of very prominently stood out to me in my career, really guide me on a day-to-day basis and just how I think of the projects that we work on for clients, and making sure that we're both trying to be engaging to the public as we go through the process, but also really to make sure we are clear, we are articulate, and we build a record of information that makes sense as to why these things fit within these plans and policies. But as a quick follow-up to your experience on the hearings board, to the extent you're comfortable, sharing details and some of those sorts of things, among the decisions that you worked on, is there, one or two that kind of stand out for you as most foundationally important in those early days of GMA?
I have more than one or two. I think I can cover 4 or 5 of them pretty quickly. You mentioned show your work, which is something that the board said in one of the cases that was, I think, the very first case we had involving Kitsap County, City of Bremerton, and about 15 other petitioners, all filed an appeal of Kitsap County's comprehensive plan. We said many things in that decision, one of which was, you need to show your work. You need to explain, how did you conclude the UGA should be this big? What's your data? What was your methodology? Show your work. You need to show your work to explain yourself. Totally apart from, is the work that you did compliant? I mean, that's a separate question. The other thing that we, I think, did in that case, which lives in either infamy or the opposite of infamy, is the whole question of, well, what is urban density? Some of the cases that were reviewed by us in the 90s really went to the question of, is 8 units per acre urban? How about 5 per acre? How about 2 per acre? They were rooting around for, well, what's the right number? Because the statute didn't tell you that. Even the WACs didn't tell you that. So we, in our decision, said, well, clearly, if you've got a lot that is 4 units to the acre, generally speaking, I think we should have stayed with the word generally speaking, that's urban. I mean, if you want to contest that a city has adopted a density of 4 per acre and want to argue that that's not urban, that's going to be really hard to persuade us that that's the case. So I think right away, people seized on the fact that the term bright line was used in the decision, where we said that the bright line of what is urban is 4 per acre. Not a hard line, not a brick wall, but a bright line that if you're at that level or above, you're urban. If you're below that, show your work, make your case. We had a later case, Litowitz versus Federal Way, where Litowitz was pointing, rather the city of Federal Way was pointing to the fact they had like a large wetland system, the High Lobos wetlands, many acres of wetlands that they didn't want to designate as 4 per acre. So they designated it a much lower density and said, we think that's an appropriate urban density. What do you think? We agreed. We said, well, there are circumstances sometimes where Less than 4 is the right urban density because the whole thing is in the city. So by definition, it's in a UGA. So that was a case where I think we illustrated when we said generally speaking, 4 per acre is urban. Less than that could also be urban depending on the circumstances. People though latched on to the use of the term bright line, which is a legal term. Not a lawyer, didn't come from me, but we were trying to convey to people, hey, here's a clear indication in the law of how you can be guided by this. Well, that showed up in a Supreme Court decision several years later that actually wasn't a GMA case, but the Supreme Court at the time said, wait a minute, the Growth Hearings Board can't make a rule legislatively that applies statewide. You really should be operating more like a Superior Court. The 2 parties in front of you, A wins, B loses, go away. What you decided applies to A and B. It doesn't apply to anybody else, and don't cite to the Superior Court decision when you file another case. So we understood that, but it's interesting to me that I did work for PSRC a little bit later and asked the question of all the cities of the region, what is your minimum lot size? What do you consider to be an appropriate urban density? 95% of them had landed on 4 per acre. A handful of them, 3 or 4, said, wait a minute, we're going to go lower than 4 per acre because we think that's also appropriate. Those were never litigated. We never really had to answer those. But generally speaking, if 4 per acre is, I think, a major foundational idea that came out of that Bremerton case, even though the Supreme Court said the board didn't have the authority to make that as a rule, applied broadly. The other thing that's kind of interesting looking back at it 30 years later, per acre is a 1/4 acre lot. Given what's going on now, that's a large lot. So everything is relative and perceptions and needs change over time. So Bremerton is one of them. Another one I'll name is Bainbridge Island. I don't mean to pick on them, but they did this twice. This is a public participation requirement. You have a duty to tell the people what you're considering to do. You have to give the public a chance to say what you think about that. You don't have to agree with them. Almost by definition, you can't agree with them because they don't agree with each other. But what we did say in the cases that we had from Bainbridge Island was you made a change after you had the recommendation from your planning commission and didn't give the public a chance to say what they thought about that. So it was appealed. We said, you have to go back to the wickets. You have to give a new notice, give people a chance to say what they think about that, and then you'll do what you do. So in that case, they did that. They opened up the hearing. They had a hearing. This person expressed their opinion. The city council respectfully said, thank you very much. And then they promptly did what they had done before. Well, when people said, well, you're just making them go through the wickets again, what's the point of that? Well, there was another case involving King County, where the King County Council, for different reasons, did the same thing. They made a change after the record was closed. Nobody had a chance to comment. That was appealed, came to the board. So we said, citing, I think, this case from Bainbridge, look, you need to give people a chance to be heard. You don't have to agree with them, but you have to give them a chance to be heard. In that case, they had a new process. They changed their mind. They did something different. So the point is, you need to listen to the public. You need to give them a chance to say what they want to say. That does not mean you have to agree with them. So that was King County and Bainbridge cases. The other one I want to mention, Linwood and Edmonds versus Snohomish County. This was a case where the cities were saying, hey, Snohomish County can't tell us how many people we have to plan for. This was an early 90s case. And the board looked at that and looked at the requirement for the county to adopt county planning policies that must be sized. UGAs must be sized for 20 years worth of growth, which inevitably meant they had to account for where's this going to go. So we interpreted, yes, they have the authority to assign population actually and employment targets to cities. So that was, everybody takes that for granted now, but that all flowed from that case. One other one I want to mention briefly is the transformation of local governance that we talked about in the Snoqualmie decision. It was Snoqualmie versus King County, very complicated case. It really dealt back to the roles of cities and counties. And what we concluded there was that the role of the county is to make regional policy, make population allocations. I think we even cited the Linwood decision. They have to have the authority to do this. It's a regional decision. 210 says they're regional governments, but they don't have the authority to tell a city specifically how you're going to do that. 210 talks about the role of counties as regional policymakers, role of cities as the primary providers of urban services. CPPs, countywide planning policies, may not alter the land use powers of cities, another undefined term. So what does that mean? Well, in Snoqualmie, we concluded what that meant was development regulations. So they can't tell you that the population that we're allocating to you as a city, using our authority as a regional policymaker, has to be at the corner of X and Y with buildings of this density and this height. That's a land use power. That's the city's business. That's not the county's business. So we did some, again, role clarification. And the idea that a city is the place where a lot of those decisions should be made at the local level is what I think inspired a lot of the incorporations and annexations that we saw, that I think were inspired by the Growth Management Act. I could talk about other cases, but let me stop there.
Oh, that's awesome. I mean, I've been involved in so many different things, and not just the planning perspective, like actual physical projects, but the planning projects that are kind of in advance of larger projects. So, your sub-area plans and some of these other types of things. There's so much of that. I don't think people quite understand just the significance of hearings board decisions early in this process. I mean, even in the case of extension of utility infrastructure, can a city extend utility infrastructure outside of city limits? Yes. Can it extend it outside of the urban growth boundary? Well, yeah, but in the case of sewer, no. And then the other questions coming before the board of can a jurisdiction withhold service until after annexation because they want to have it annexed first so that it's built in accordance with city standards? I mean, those are still kind of questions out there today as cities and counties struggle to deal with this infrastructure question. And really, if you go back to it, kind of how I see it, having at least some structure of growth management eliminated kind of what I would call the Wild West way of serving growth, which was, you might have a couple of competitive jurisdictions or competitive water and sewer districts. And, if a project came along, one may say, no, we don't want to make an investment in extending our utilities that far. Yet the other one may look at it and go, geez, that might be really worth something to us someday if we extend our utility infrastructure that far. Yeah, absolutely. We're down. Let's do it. And those not necessarily being great planning decisions, but more decisions of territory and power and those sorts of things. So the role that the Growth Hearings Board has played in this process of planning, I think, has been very, very important. And I think it's often a piece of the planning process, because it's part of the life cycle of planning, really, in growth management. And it's a process that most of the public probably doesn't know a lot about, nor really has had anybody talk about to explain kind of how some of these things have been shaped over time and, how we've developed some of the ways of thinking about growth management that we now have. So appreciate you getting into, several of those cases, especially some of those early foundational cases.
Thank you all so much for watching this episode. Be sure to subscribe and check out our previous and upcoming content, and keep an eye out for future episodes from this series. We hope to see you again next time on Permitted with Conditions.